accused number one's counsel for discharge in terms of section 174, as well as the response of the state to that application. There were timelines that were set down for the submission of the heads of argument by the counsel for accused number 4, as well as for the state. Both parties have adhered to the timetable.
Yes.
And hard copies, my lord, have been prepared for the court and have been given to the court's registrar this morning. Both
Okay.
the heads for accused number 4 by his counsel, Advocate Khumalo, as well as for the state. But just before we commence, my lord, Advocate Nisi has intimated that there is something that they want to put on record. I'll just take my seat and allow him to address the court.
As it please the court, my lord, it's not a big thing though. It relates to Mr. Sibiya. Apparently there's a misunderstanding where he's being housed at Morabi Correctional Facility about the court starting time in the matter. Because apparently the head there, I don't know whether it's a head or it's a divisional head, keeps on receiving messages, phone calls, I don't know from who, to the effect that the starting time of this court here, it's 9 o'clock. So I don't know where that comes from. So apparently he requested through Mr. Sibiya that at least the court should clear the starting time of this matter, my lord. I've been saying to him, no, the official starting time of this matter it's 10 o'clock. I don't know where the 9 o'clock comes from. So is it now? I think that needs to be cleared, my lord. I think there's a gentleman there who also can affirm that position. Is also from Morabi Correctional Facility, my lord.
Okay.
Thank you.
Yes, sir. Where's the gentleman? Yes, let's hear. What do you know about this 9 o'clock, 10 o'clock story?
We were also told this morning that we should be here at 9. So we should leave Morabi as early as possible. That's the message we got.
Also, it's an instruction from your section.
Yes.
And if you're not here at 9, what happens?
I don't know much, but it just came as an instruction that.
Yeah, okay, no, fine. The court starts at 10. So if the gentlemen before us come at 9, it's still okay, because at 10 o'clock they'll be here. Okay. That's the official starting time.
Thank you, madam.
10. Okay, thanks. Yes, Mr. Nxumalo.
I'm ready.
Yes.
To
Are we
proceed.
ready to start, Mr. Baroit?
Indeed, my lord.
Okay, so, yeah. Yes, sir.
This is an application in terms of the provision of section 174 of the Criminal Procedure Act 51 of 1977 with respect of accused number 4. Introduction. The provisions of section 174 of the Criminal Procedure Act, the Act provides as follows. If at the close for the prosecution, for the case for the prosecution at any trial, the court is of the opinion that there is no evidence that the accused committed the offense referred to in the charge or any offense of which he may be convicted on the charge, it may return a verdict of not guilty. The background. The deceased Mr. Senzo Meyiwa was a well-known professional footballer who played for Orlando Pirates as a goalkeeper in the Premier Soccer League and for the South African national team Bafana Bafana. The deceased was shot and killed in the house of his ex-girlfriend, Miss Kelly Khumalo, on the 26th of October 2014 while paying her a visit. On the 16th of June 2020, the investigating team led by Brigadier Geninda, who is the head of the National Court Cases arrested Bongani Ntanzi, accused number 2, in respect of this case. On the 19th of June 2020, accused number 2 made a confession statement before a commissioned officer, Colonel Rapado. On the 24th of June 2020, accused 2 made a second confession statement before a magistrate, Ms. Cronje. It was on this basis that a confession statement which led to the arrest of accused number 4 before court. On the 17th of July 2023, the trial commenced de novo, and it has been on a running roll for a period of over 2 years. It has been televised national and international and on print media. It has also been marked by delays during this period. Accused number 4 has been in attendance throughout the trial. It is no doubt that at some instances, valuable court time has been wasted. The rationale for section 174. The rationale for the rule in terms of section 174 was described as in State versus Morera, unreported GP case number A523 of 2015, dated 22 January 2016 at paragraph 54. And I quote, "It caters for the prescript of the Constitution for the fair criminal trial, namely the presumption of innocence on the part of an accused until proven guilty and his or her right to silence. It further puts an abrupt end to a case which has no prospect of being successful in circumstances where the evidence falls abysmally short in proving even a prima facie case against an accused, thus ensuring that valuable court time is not wasted and unnecessary expenses not incurred." Section 174 thus gives the court to decide not to put the accused on his or her defense if there is no case to answer. There is no formula for or test applicable to all circumstances when deciding whether or not to discharge. Each case must be decided on its own merits in order to reach a just decision. The charges. The accused, including accused number 4, are charged with the following offenses.
ngaphansi kozomthetho section 174 ethizima ukudedela kumacala wonke abakade bamthosa wona ke lapho ke lasho khona ukuthi lesi isicelo siwela ngaphansi kozomthetho lapho ke section 174 ngaphansi kozomthetho la 9 eNingizimu Afrika ke ngaphansi ko act 51 ezomthetho ka 1977 lathi khona ke egcineni kwecala ke lozombuso ke uma ngaba ke khona kanjalo ke lokuzana ke bebona ukuthi abanalo icala lapho ke komethi abasolwa ke badedelwe ke mana namcala la kade bebathosa wona ke lapho ke futhi abathole bengenawo kamacala ke futhi washo khona njalo ukuthi mabefunda lapho ku background ngaphansi kwe background lapho ke bathi khona kanjalo umuntu washona ke lapho ke uSenzo Meyiwa ke kade saziwa kakhulu njengomdlali webhola ke futhi edlala njengo-goalkeeper ke lapho ke futhi umdlali odlala ngaphansi kwamapali futhi edlala iqembu le-Orlando Pirates futhi edlala ngaphansi kuyona ke Premier Soccer League futhi neqembu lana ke eNingizimu Afrika ke labafana ke bathi wadutshulwa ke ngelanga wadutshulwa emzini we-ex-girlfriend yakhe usho intombi ke kade athandana nayo ke lapho ke ukhili Khumalo ngelanga lange-26 zaka-October ngomnyaka 2014 ngesikhathi kade amvakashele khona ke kumuzi wakhe ke lapho ke bathi futhi ngelanga lange-16 zaka-June ngomnyaka ka-2020 khona ke njalo ke ithimba labaseshi ke lapho ke kade laholwa ke lapho kuBrigadier Gininda ke ilona ke osebenza ngaphansi kwama-cold cases awabopha khona njalo ebopha khona lapho ke uBongani Ntanzi ke ngokumsola wesibili ke lapho ke bese ngelanga lange-19 zaka-June ngomnyaka 2020 lapho ke umsola wesibili ke bese wabhala ke statement noma wenza ke confession ke eyenza ngaphansi kwe-commissioned officer ekukade ku-Colonel Rapado lapho ke ngelanga lange-24 zaka-June ngomnyaka 2020 ke lapho ke umsola wesibili bese wabuya futhi wenza confession yesibili ke lapho ke noma statement ngaphansi kukamantshi ke lapho ke uMr. Cronje lapho ke kumakhona ke phecelezi ngodaba le-confession lapho-ke la kade khona-ke futhi ngemuva kwalokho kwey'tatimende zakhe azenzile lapho-ke kwagcina sekuboshwa khona-ke njalo lapho umsola wesine-ke lapho-ke bathi khona njalo-ke ngelanga lange-17 zakajulayi ngomnyaka 2023 khona-ke lapho-ke icala leli aqala-ke phansi lahlala phansi lapho lahamba lihlala khona njalo-ke bathi sekuphile-ke isikhathi seminyaka-ke emibili-ke icala likade likhulunywa khona njalo-ke futhi icala likade beliqhamukisile mhlawumbe belikhangisa kumabonakude-ke lapho-ke balake eNingizimu Afrika futhi ngisho nangaphesheya kwey'lwandle lapho-ke futhi nangaphansi kuma-print media basho khona njalo ukuthi-ke khona-ke kade khona-ke iy'ngqinamba ekade zikhona-ke lapho-ke ezenza ukuthi icala lingahlali ngesikhathi esanele mhlawumbe kade khona kuphazamisa phakathi kwicala leli-ke lapho-ke basho khona njalo ukuthi uma ngabe sesikhuluma ngesicelo lesi saka-section 174 khona-ke lapho-ke bathi khona njalo uma sizoqhathanisa phakathi kwicala lika-SF icala likambuso-ke futhi libhekane khona-ke lapho-ke nomurero bathi khona-ke kade lingareportiwe lapho-ke elalana-ke e-GP wathi ngaphansi kwe-case number u-A523/2015 date lange-22 zakaJanuwari ngonyaka 2016 lapho-ke ummeli kade aqhathanisa nje kuphela kulelo cala leli nakecala leli esikulona-ke futhi kasho khona njalo ukuthi ngesikhathi bekafunda futhi washo khona njalo ukuthi ngaphansi kwezomthetho ka-section 174 uma ngabe-ke umsola mhlawumbe umsola okuwesilisa noma owesifazane noma wesimame-ke lapho-ke bengenayo icala lokuthi aphenduleke lapho-ke lokhu kuvame ukuthi mhlawumbe kusetshenziswe-ke khona-ke lapho-ke ngaphansi kwento ekusuke mhlawumbe benayo ehlangothini lezombuso-ke lapho-ke.
The accused, including accused number 4, are charged with the following offences. Murder read with the provision of section 51, subsection 1 in bracket of the Criminal Law Amendment Act 105 of 1997 as amended, and further read with sections 92 subsection 2 in bracket 94, 256, 261 of the Criminal Procedure Act 51 of 1977. In that upon or about the 26th of October 2014 and at near Fostoras in the district of Boksburg, the accused did unlawfully intentionally kill Mr. Senzo Meyiwa, a 27-year-old male, by shooting him with a firearm. The provisions of section 51 subsection 1 in bracket of Act 105 of 1997 are applicable in that the murder was planned or premeditated. B, the death of the victim was caused by the accused in committing or attempting to commit, or after having committed or attempted to commit robbery with aggravating circumstances, as defined in section 1 of the Criminal Procedure Act 51 of 1977. C, the offense was committed by a person, group of persons, or syndicate acting in the execution or furtherance of a common purpose or conspiracy. Count 2, attempted murder. In that upon or about 26 October 2014, and at or near Fostoras in the district of Boksburg, the accused did unlawfully intentionally attempted to kill Zandile Lorraine Khumalo, an adult female person, by shooting at her with a firearm. Count 3, robbery with aggravating circumstances as defined in section 1 of Act 51 of 1977, read with the provisions of section 51 subsection 2 of the Criminal Law Amendment Act 105 of 1997 as amended, and further read with sections 92 subsection 2, 94, 256, 261 of the Criminal Procedure Act 51 of 1977. In that upon or about 26 October 2014, and at or near Fostoras in the district of Boksburg, the accused did unlawful intentional assault Miss Kelly Khumalo and or Gladys Khumalo, and did with force and violence take a Samsung S4 cell phone, the property or in lawful possession of Miss Kelly Khumalo and or Gladys Khumalo, and did rob her of same. Aggravating circumstances being present in that the accused made use of a firearm. The provisions of section 51 subsection 2 of Act 105 of 1997 are applicable in that there is presence of aggravating circumstances. Count 4, contravention of section 3 of the Firearms Control Act 60 of 2000, possession of firearm. In that upon or about 26 October 2014, and at or near Fostoras in the district of Boksburg, the accused did unlawfully and intentionally have in their possession a firearm to with a 9mm CZ Model 75 with obliterated serial number without being in possession of a license to possess the said firearm. In respect of this count, the state alleges that the accused jointly possess a firearm which is the subject matter in this count. Count 5, contravention of Section 90 of the Firearms Control Act 6 of 2000, possession of ammunition. In that upon or about the 26th of October 2014, and at or near Fostoras in the district of Bospek, the accused did unlawfully and intentionally have in their possession an unknown number or quantity of 9mm parabellum caliber ammunition without being in lawful possession of a firearm capable of firing such ammunition.
Section 51 subsection 1 wezomthetho lana eNingizimu Afrika kwela ngaphansi ko-Act 105 of 1997 futhi uma siqhathanisa uma sihanjiswa neminyaka yezemithetho-ke lapho-ke ingaphansi ko-subsection 92 subsection 2, 94, 256, 14 or 261, Criminal Procedure Act 51 of 1977. La bathi khona-ke ngelanga lange-20 bathi ngelanga lange-26 October eduze nendawo se-Fostoras-ke lapho-ke noma ngaphansi kwesigodi sase-Bospek-ke lapho-ke bathi khona-ke khona njalo umsolwa abasolwa benza lokhu futhi ngongemthetho futhi ngenhloso ngesikhathi kade bebulala khona-ke lapho-ke uSenzo Robert Meyiwa kade eneminyaka-ke u-27 usuthi amashumi amabili anesikhombisa-ke ubudala-ke futhi wesilisa-ke bathi ngesikhathi kade edutshulwa-ke lapho-ke ngesibhamu-ke lapho-ke bathi lokhu kula-ke ngaphansi kwezomthetho-ke lapho zika-51 subsection 1 we-Act 105 of 1997 ushuthi lapho-ke ushuthi umuntu ushuthi lokubulala kwabo-ke bahlela phansi noma bacabanga bese bahlela phansi ngesikhathi kade bekwenza-ke lapho-ke futhi yabuya futhi aqhubeka khona zathi ukushona kukamufi-ke lapho-ke kwakuyimbangela yokuthi kade khona-ke abantu abangena bese bebenza lokudlala nobugebengu kade babenza ngaphakathi-ke lapho-ke noma bezama ukuthi babambe inkunzi lapho ngesikhathi futhi bebamba-ke inkunzi kade ephetheke ikhali-ke kubona-ke bade kokwela-ke futhi ngaphansi kwe-section 1 wezomthetho eNingizimu Afrika-ke Criminal Procedure Act 51 of 1977 la bathi futhi khona-ke njalo kusho lamacala-ke la kade benziwe khona-ke lo muntu oyedwa-ke noma mhlawumbe iqembu-ke labantu kade lisebenzisana lonkana-ke ekuthizeni bafezekise lokuzana isifiso sabo sokuthi benze lokho mhlawumbe ukuhlela-ke ukubulala-ke lapho-ke bathi icala lesibili-ke lapho-ke ukuzama-ke ukubulala-ke bathi ngelanga lange-26 zaka-October ngomnyaka ka-2014 eduze nendawo yase-Fostoras noma ngaphansi kwesigodi sase-Fostoras bese ngaphansi kwendawo yase-Bospek-ke lapho-ke bathi-ke abasolwa mhlawumbe kumsolwa wenza lokho ngomthetho futhi ngenhloso-ke la kade ezama khona-ke ukubulala khona-ke lapho-ke uZandile Lorraine Khumalo-ke okade kuwumuntu wesimama-ke omdala ngesikhathi kade bemdubula-ke bese kade kusetshenziswa-ke isibhamu-ke lapho-ke bathi futhi icala lesithathu-ke lapho-ke ukubamba inkunzi-ke lapho-ke niqhobile mhlawumbe bephetheke ikhali kinina-ke ezinobungozi-ke lapho-ke bathi zikhona-ke lokho kukhulunywa ngaphansi kwezomthetho zaka-section 1 Act 51 of 1977 futhi ifundeka nezinye-ke zemithetho-ke lapho-ke section 51 subsection 2 yezemthetho lana-ke eNingizimu Afrika-ke lapho-ke ngaphansi kwezomthetho zaka-Act 105 of 1977 futhi uma seyejobelelwa-ke ihambisana-ke neminye-ke imithetho-ke lapho-ke isizohamba-ke no-section 92 subsection 2 section 94 section 256 futhi no-section 261 yezemthetho lana-ke eNingizimu Afrika-ke wela ngaphansi kwezomthetho-ke 51 of 1977 la bathi khona-ke ngelanga lange-26 zaka-October ngomnyaka 2014 eduze nendawo noma ngaphansi kwendawo se-Fostoras ngaphansi kwesigodi sase-Bospek khona-ke lapho-ke la khona-ke abasolwa benza khona-ke ngongemthetho futhi nangenhloso-ke ngesikhathi kade bezama khona-ke lapho-ke ukuthizeni besenza lokhu kade bekwenza kulapho ku-Miss Kelly Khumalo noma uGladness Khumalo ngesikhathi kade bemphoqa-ke lapho-ke noma ngongemthetho bemthathe lapho kumakhalekhukhwini wakhe kade kuyi-Samsung S4 cellphone yakhe-ke lapho-ke futhi kade kuyeyakhe-ke bayithatha ngaphandle kuthina-ke bavuma ukuthi bayithathe-ke lapho-ke nombamba ke inkunzi lapho ke uKaylee Khumalo noma uGladness Khumalo ke lapho ke ngesikhathi ade nithatha lokho futhi ade nisebenzisa ke nakhe lapho ke isikhali ngesikhathi ade nisenza lokho ke bathi lokho khona ke ngaphansi kwezomthetho zaka section 51 subsection 2 act 105 of 1977 ezomthetho shothi lapho ke iyangenelela phakathi ke lapho ke labathi khona ke nina kade nisebenzisa ke isikhali ngesikhathi ade nisenza lokho ke bathi icala lesine nibukene nalo ke uyicala lokutholakala ke niphethe ke isibhamu icala lwela ngaphansi kwezomthetho ke noma kungahambisani nomthetho ka section 3 umthetho wezibhamu ke lapho kwela ngaphansi ko act 60 of 2000 sokunatholakala lapho ke niphethe ke isibhamu ngemthetho ke bathi ngelanga lange 26 October ngomnyaka 2014 duze nendawo noma ngaphansi kwendawo seFosforus bese ngaphansi kwesigodi lapho sasebosbek bathi khona ke abasola benza lokho ngemthetho futhi ngenhloso ke ngesikhathi ephethe khona ke kubona ke isibhamu kade kuyi 9mm CZ model 75 lapho kade inombolo zakhona ke kade zicishiwe zingasabonakali kahle ke kuleso sibhamu leso ke nade nesiphethe futhi ngaphandle kokuthi liphethe ke amaphepha akade enikeza imvume noma ilungelo ukuthi nisebenzise ke isibhamu ke lapho ke bathi lokho ke iyona ke into ithimba noma ihlangothi lozombuso ke abanishushisa ngayo ke leyo ke bathi futhi icala lesihlanu ke lapho ukuthi nitholakale ke lapho ke ningahambisani ke nomthetho ka section 90 wezemthetho umthetho ezibhamu noma mhlambi izinhlamvu ke lapho ke ewela ngaphansi kwe act 60 of 2000 la bathi khona ke nina ke ngelanga lange 26 October ngomnyaka 2014 duze nendawo noma ngaphansi kwesigodi saseFosforus bese ngaphansi kwesigodi noma ngaphansi kwendawo yaseFosforus bese ngaphansi kwesigodi sasebosbek la kade nina ke nenza ngemthetho futhi ngenhloso ke lapho ke ngesikhathi kade nitholakala niphethe khona ke lokuzana izinhlamvu eziningi kunina ke inhlamvu lezo kade kuyinhlamvu zelokuzana ze 9mm parabellum caliber suthi isibhamu sakhona ke leso ke suthi lapho bathi inhlamvu zesibhamu leso ke then nitholakala niphethe lapho ke futhi bathi inhlamvu lezo kade niphethe ke inhlamvu eziningi ngendlela engajwayelekile noma engavumelekile.
The summary of substantial facts in terms of section 144 subsection 3 in brackets not letter A in bracket of Act 51 of 1977 details amongst others that there were several other persons in the house, namely Miss Gladness Khumalo, the owner of the house, who is the mother to Kelly, Miss Zandile Lorraine Khumalo, sister to Kelly, Mr. Longwe Twala, boyfriend to Miss Zandile Khumalo, Mr. Tumelo Madlala, friend to Mr. Senzo Meyiwa, and Mr. Mthokozisi Twala, a friend of Mr. Senzo Meyiwa in the lounge or dining room. A cell phone belonging to Miss Kelly Khumalo was taken and the assailant fled, dropping a head on the premises. It is important, my lord, to mention that in respect of count 3 of the indictment, Ms. Kelly Khumalo was not called to testify despite being the complainant in that count.
Despite what?
Despite being the complainant in that count, in count number 3 of the
I thought there were
indictment.
2 complainants. Mr. Valoy, is that not so?
Yes, indeed, the other complainant is the mother.
The mother, yeah.
Yes,
Yeah.
both of,
Okay.
in fact, I should say, my lord, that both of them were not called before this court to come and testify about the circumstances of the robbery, which occurred on the 26th of October 2014 in the house in their presence. The state will allege that the accused were acting in the furtherance of a common purpose to commit the crimes as per the indictment. The duties of a prosecutor. In terms of Section 25 of the National Prosecuting Authority Act 32 of 1998, determines the powers, duties, and functions of prosecutors. Section 25, subsection 1, provides that a prosecutor shall exercise the powers, carry out the duties, and perform the functions conferred or imposed on or assigned to him or her, A, under Act 32 of 1998 and any other law of the Republic. B, by the head of the office or investigating directorate where he or she is employed or person designated by such head. Or C, if he or she is employed as a prosecutor in the lower court by the DPP in whose area of jurisdiction such court is situated or a person designated by such DPP.
wezinto kade zikhona-ke lapho-ke shukuthi mhlawumbe isihlahla msindo-ke lapho-ke lathi khona-ke kade khona-ke abantu abaningi kade bekhona ngaphakathi kwalowo muzi walapha-ke futhi uqala kade akhona-ke lapho-ke bathi owesimame lapho uGladness Khumalo futhi yena-ke umninimuzi walapho-ke kulo muzi walapho kwaKhumalo-ke lapho-ke bathi wesibili kade khona kuzandile Lorraine Khumalo-ke kade kuwusisi kaKheli-ke lapho-ke futhi umnede kade kukhona-ke umnumzana uLongethwala kade kuyi-boyfriend noma sothi ushuthi umuntu ohlekisana noZandile Khumalo-ke lapho-ke futhi noTumelo Madlala-ke lapho kade kumngane kaSenzo Meyiwa futhi uMthokoziseni Thwala-ke lapho-ke naye kade kuwumngane kaSenzo Meyiwa lapho-ke athi bonkana labo bantu kade behlezi-ke lapho-ke kule ndawo yokuhlala shuthi mhlawumbe yokuhlala ngaphakathi komuzi-ke bathi ngesingisi-ke i-dining room-ke lapho-ke bathi ngesikhathi kade kusenzeka lokhu-ke kwathi khona-ke abantu ababili-ke lapho-ke abangena ngaphakathi kwalo muzi ngesikhathi kade bengena kade behlubile kubona futhi bafuna-ke imali futhi nelokuzana namacingo-ke lapho-ke athi-ke lapho-ke ummeli-ke ukhumbule khona njalo-ke ukuthi bonkani labantu ekukhulunywa ngabo-ke lapho-ke thizeni madatha babakhuthuza lapho noma mhlawumbe babamba inkunzi-ke lapho-ke abakaze beze bazoletha ufakazi babo ngaphambi kwenkantolo-ke lapho-ke futhi uyafunda manje uma uqhubeke efunda khona njalo lapho-ke mayelana nesikhangiso sakamshushisi-ke lapho-ke athi mayelana nezomthetho lapho section 25 owela ngaphansi kwezomthetho lapho National Prosecuting Authority lapho-ke Act 32 of 1998 uyasho khona nje uyakhuluma ngendlela kumele abashushisi basebenze ngayo-ke uma besebenza mayelana phecelezi nozomthetho mayelana nodaba lozomthetho-ke lapho-ke athi ngaphansi kwe-section 25 subsection 1 iyona ekhuluma phecelezi ngodaba labashushisi ukuthi kumele basebenzise kanjani-ke amandla wabo-ke uma ngabe bephethe umsebenzi wabo besebenza lapho-ke phecelezi nodaba lamacala uma ngabe abashushisi-ke lapho-ke besebenza sithi mhlawumbe kwinkantolo-ke incane-ke lapho-ke noma besebenza ngaphansi nje kokuphenya kwamacala noma ekusizeni ekuthizeni amacala aphothulwe ngaphambi kwenkosi yenkantolo-ke lapho-ke noma besebenzela ngaphansi kwe-DPP-ke lapho-ke beyakhuluma ngodaba lolo-ke kuphela.
The prosecutor has a duty to pay attention to the contents of the police docket. In this regard, see Minister of Police and another versus Duplessis, 2014, Volume 1, SACR 217, SCA. The summary of substantial facts in terms of Section 144, subsection 3, in bracket, small letter A in bracket of the Act 51 of 1977, details that the deceased, Mr. Senzo Meyiwa, died during or after the commission of the robbery, which gone wrong. Brigadier Kininda, in his evidence, details a hit to kill the deceased and based this argument in the investigation done and or conducted by the investigating team on the following. The evidence of Colonel Lambertus Stein. Colonel Stein testified that he was employed by South African Police Service and in the service of the state, attached to the National Court Case Unit investigation based in Pretoria, National Head Office, where he acted as an analyst and an investigating officer. On the 9th of April 2020, at about 10 o'clock, he received a series of Section 205s and cell phone downloads from the investigating officer, Brigadier Kininda. He testified further that Brigadier Kininda requested him to determine if there are any linkages between the current suspects and the people in the house at the time of the crime. The transcribed record of the 27th of July 2023 at page 64, line 10 to 15, states the following. Mr. Stein, I just want to draw attention to the court that as well that a Section 205 information, not one of the team members applied for that, but it was stored on the central database of the police. So that is why it was being applied for by the previous investigation officers. But we did have access to that.
sifunda futhi phecelezi nodaba la ke lapho-ke lokusebenza lapho-ke kwethimba labashushisi ke lapho-ke bese kuyaqhathanisa phakathi kwecala lapho-ke lika-Minister of Police futhi nabanye-ke lapho-ke no-DPLC lango-2014 volume 1 SACR 217 lapho-ke athi khona-ke njalo lapho-ke athi khona-ke udaba phecelezi bathanda ukukhuluma ngalo-ke lapho-ke uma ngabe khona kufakazi obukhethekile noma ufakazi obabukhethile nocaphulile ekuthizini enza aqhathanise phakathi kwabo-ke lapho-ke lathi khona-ke ubufakazi ade bukhulunywa lapho kumnumzana uColonel Lambert Stein osebenza ngaphansi kwezesiphoyisa-ke lapho-ke la bakhuluma khona ukuthi yena-ke ngesikhathi lesi ngelanga lange-9 zaka-April ngonyaka 2020 lapho ngehora laka-10 kusasa-ke wathola-ke ucingo lapho oqhamuka lapho ngaphansi kwe-section 205-ke lapho-ke lezo zokuthwebula kwemininingwane ngaphakathi kwamacingo-ke lapho-ke la bacala khona kuBrigadier Gininda khona-ke lapho-ke athi ukuthi yena umsize ngesikhathi batestify lapho noma ngesikhathi beqeda ethula ubufakazi bakhe-ke lapho-ke athi yena akabheke ukuthi noma ngesikhathi bamcetha akabheke ukuthi ngabe khona yini uxhumana phakathi kwalabantu bekhona ngaphakathi kwamuzini-ke ngesikhathi salo bugebengu lobuke lapho-ke bese-ke yacaphula ngaphansi kokushicilelwa inkantolo ngelanga lange-27 zenyanga kaNtulikazi ngonyaka 2023 lapho kwikhasi le-64 lapho kumugqa wesi-10 kuze kufince kumugqa wesi-15-ke lapho-ke la umnumzana uStein wakhuluma khona-ke lapho-ke ekuthizini wacelwa njalo akadobeke lapho kusebenza kwakhe noma ukusebenza ngaphansi kwenkantolo-ke lapho-ke ngaphansi komthetho section 205 lapho-ke nemininingwane kade anayo lapho-ke futhi wacela amaphoyisa-ke lapho-ke ekuthizeni enze lolo daba-ke lolo mhlawumbe lo cwaningo lolo msebenzi-ke lapho-ke athi lonkana lucwaningo kade beshicilele ngaphansi kwe-database yezesiphoyisa-ke lapho-ke athi khona-ke njalo futhi leso sicelo kade sisenziwe lapho-ke umseshi wecala lapho-ke ngesikhathi kade esikusenziwa lokhu-ke khona njalo-ke.
Then my next point, during my analysis, I discovered that Kelly Khumalo with number 278270444358, she received a call from Ntulinkani with number 277330592003. This appears from the transcribed record of the 27th of July 2023 at page 75, line 6 to 9. According to Colonel Stein, communication between the two numbers occurred on two separate occasions. That is on the 2nd of August 2014 and 15th October 2014. The details of the communication are reflected on page 23 of Colonel Stein's affidavit, Exhibit 01. It is important, my lord, to mention that the information from the central database of the South-Kent Police Services was editable, and the state did not call any witness to authenticate it during the course of this trial. The state, by this communication, that is communication between the two numbers, intended to prove communication between the mastermind, which according to the brigadier, that is Brigadier Gininda, was Miss Kelly Khumalo and accused number 5. Accused number 5 then procured the services of his co-accused, that is accused 1 to 4, in the execution of the murder. The evidence of Miss Pinky Vitilingam.
La futhi ngisho khona njalo kwecaphula kunkulumo kade khuluma lapho umnumzana ke uStein lapho ke ngaphansi kwekhasi lama-23 ke lapho ke la ecapha khona ke khona ke njalo yena ke into umsebenzi kade awuceliwe ekuthizeni ke awenze lapho ukuthi agqinize kabanzi ekuthizeni enza ama-analysis ke lapho ke phecelezi nodaba phakathi kwakaKelly Khumalo ke kwinombolo zakaKelly Khumalo ke lapho ke ezihamba ngalo 082 7044 358 lezi athola khona ucingo kuzona ke kade qhamuka lapho ke kuNtulinkani futhi naye kade enale inombolo lezi landelayo ke lapho ke kade ku 0733059202 lapho khona lokho kade kukhona kushicilelwe ngelanga lange-27 ngenyanga kaNtulikazi ngonyaka 2023 lapho ke ngaphansi kwe-page lapho ke noma ikhasi le-75 uqala kumugqa wesithupha kuze kufince kumugqa wesi-9 ke lapho ke lathi khona ke njalo ngamalana nodaba lwabaColonel Stein lathi khona ke kodwa khona ke ukukhuluma phakathi kwabantu ababili kade kusenzeka lapho-ke futhi amahlandlo amabili-ke lapho-ke futhi ihlandlo lokuqala noma isikhathi sokuqala kungelanga lange-2 zaka-August ngomnyaka 2014 bese-ke ilanga lesibili-ke lapho-ke kade kuyilanga lange-15 zaka-October ngomnyaka 2014-ke lapho-ke yonkana le mininingwane iyona-ke ngaphansi lapho-ke noma inkulumo yabo-ke kade khona-ke ngaphansi kwe-page 23 laka-Colonel Steyn ngaphansi kuyafidality kade ayibhalile ewela ngaphansi kuka-Exhibit O futhi washo khona nje ukuthi ihlangothi ithimba lakhe lapho-ke noma into kade ithimba leziphoyisa kade lenza-ke lapho-ke ukuthi uxhumanise-ke abantu laba bonkana futhi-ke phecelezi nodaba lenkulumo iqhamuka kuhlangothi lwezombuso-ke lapho-ke ukuthi baqhamukise ukuthi kade khona-ke inkulumo kade khona phakathi kwalabantu bonkana noma lo muntu kade aqashile-ke abantu laba-ke futhi nomsola wesihlanu-ke lapho-ke futhi nabanye-ke abanye kade besebenzisana naye-ke umsola wesihlanu-ke lapho-ke umsola wokuqala kuze kufince kumsola wesine-ke lapho-ke ekuthizeni baphumelelise lokubulala lokhu.
In fact, the Section 205 records from Vodacom depicts a different scenario with regards to the communication that Colonel Steyn testified about. It details that, in fact, Ms. Kelly Khumalo with the number 278270444358 had received calls from Mr. Arthur Mofokate and the deceased on the 2nd of August 2014 and 15 October 2014, respectively. The evidence of Ms. Pinky Vitilingam. I submit, my Lord, that there were discrepancies between the analysis of Section 205 records analyzed by Colonel Steyn from the central database of the South African Police Service and the extracts of the Section 205 records, that is Exhibit J1. Ms. Pinky Vitilingam could not give an account of such discrepancies. She could only state that she could only testify about the Section 205 records from Vodacom, which depicted, as I've said earlier, my Lord, the communication on the 2nd of August 2014 and 15 October 2014 between Mr. Arthur Mofokate and the deceased Mr. Senzo Meyiwa to Ms. Kelly Khumalo. The data cell phone records do not disclose such communication between Ms. Kelly Khumalo and accused number 5 before this court. The SMSs between Ms. Kelly Khumalo and her sister Zandile Khumalo that reveal the following. In this regard, see page 6 to 12 of Exhibit 01. The trial commenced through the witnesses' evidence who were inside the house when the incident occurred, painting a picture of the robbery gone wrong. But when the trial progressed, it built around the assassination of the deceased. Brigadier Gininda described Ms. Kelly Khumalo as the mastermind and the trigger point in the execution of the deceased murder. And to that extent, Brigadier Gininda, applied for a warrant of arrest against Ms. Kelly Khumalo, which was never executed. As he says, it was a prosecutorial-driven investigation. I'm well aware, my Lord, that the state is not bound by the summary of substantial facts, which means that the evidence not disclosed therein or which differs from it will not be inadmissible on that ground alone. In this regard, see State versus Van Vuren at page 21, paragraph D to F. The court will nevertheless, in the evaluation of the state case, compare the evidence given with what the state indicated its case will be. See State versus Khumalo 1991, volume 2, SACR 203, capital letter A in bracket, at page 207, paragraph B to C. It follows that it is therefore crucial for the state case to indicate that the accused entered into an alleged conspiracy agreement with Ms. Kelly Khumalo. Failing such proof, the accused, that is accused number 4, cannot be convicted on any of the first 3 counts against him, and accordingly not on the 4th or 5th count.
La besho khona njalo kuphicelezi nodaba laloko lofakazi kade kuhamba letho umama lapho ke uPinky Vitsi lathi khona-ke njalo khona-ke kade khona-ke phecelezi udaba lwezomthetho lapho ka-section 204 kade khona-ke lapho-ke ukungahambi kahle futhi amaphutha amaningi-ke lapho-ke phecelezi nodaba lakwamnumzana uCornel Steele uma iqhathanisa lona-ke nodaba loqhamuka lapho ngaphansi kwe-Vodacom usho ukuthi uCornel Steele nako uqhamuka ngaphansi kwe-database noma wasebenzisa-ke lapho-ke i-database ezesiphoyisa-ke ngesikhathi kade senza lokhu-ke wacaphula kuyona-ke i-section 205-ke yakhe-ke lapho-ke bathi kokhona-ke kwimibukiso lapho-ke ka-exhibit triple J1 futhi nalena kapinki-ke lapho ukuthi kade noma kade bengakhulumeki ngayo-ke lapho-ke la bathi khona-ke shuthi kade ngekho-ke ilukuzana i-data cellphone record lapho-ke esho khona njalo kade khona-ke inkulumo phakathi kokheli Khumalo-ke lapho-ke nomsola wesihlanu-ke lapho-ke athi futhi noma ngakho futhi idaba lwama-SMS-ke lapho-ke kade khona phakathi kokheli Khumalo nosisi wakhe lapho uZandi Khumalo oluqhamukile lapho-ke futhi washo ukuthi khona njalo kumele sibuke lapho-ke ngaphansi kwesikhathi lesithupha kwesikhathi le-12-ke lapho-ke ngaphansi kwemibukiso-ke lapho-ke ka-exhibit 01 lapho-ke futhi ngesikhathi kuqala icala leli-ke noma ngesikhathi icala behlezi likhulunywa phambi kungasenkantolo lapho-ke athi khona-ke kade khona-ke abantu kade bekhona ngaphakathi kwela muzi-ke lapho-ke futhi bona abantu abayisithombe-ke khona-ke lapho-ke basho khona njalo ukuthi kade khona-ke abantu kade befikile lapho-ke bobamba-ke inkunzi-ke kepha lokho kazi kugcine kube sekubanjwa-ke inkunzi-ke lapho-ke kepha gcine sebahlasela futhi bagcina bebulala-ke khona-ke lapho-ke umufi-ke lapho-ke futhi athi uBrigadier Gininda naye uyena ochazile kabanzi lapho-ke athi ukheli Khumalo uyena-ke umastermind ukuthi yena-ke umuntu odlala-ke isikhangiso sokuthi lelokozana-ke usuthi uyena kade ekhona phakathi nendawo ngesikhathi kade senzeka lokhu phakathi kwabasola futhi nomufi-ke lapho-ke bathi uBrigadier Gininda washo ukuthi kukhona-ke incwadi kade icelile lapho-ke noma isicelo sencwadi kade asenza lapho-ke ukuthi lapho kokheli Khumalo nake aboshwe-ke lapho-ke kepha lokho bathi akaze kwenzeke-ke ngoba impilo yakhe kukuthi lapho-ke ngesikhathi bekasesha icala leli futhi bekasebenzisana-ke nethimba labashushisi-ke lapho-ke futhi qhubeka washo khona njalo malana nesamari yakhe lapho-ke ummeli wenu-ke kade akhuluma ngalo yofakazi nomhlaba ufakazi athi bukhona-ke lapho-ke wathi lokhu futhi yinto engekho futhi nanoma ekhuluma ngayo futhi-ke wabuya futhi waqhathanisa phakathi kwecala leka-Van Ferren lapho-ke ekhuluma ngaphansi komugqa wesi-21 noma ngaphansi kwekhasi wesi-21 qala paragraph D2F lapho-ke akhulume khona njalo futhi nangelinye icala lombuso ngesikhathi umbuso ubhekene icala laka-Hologo lapho-ke laka-1991 volume 2 CCR 203 lapho-ke wakhuluma futhi nangolunye-ke udaba-ke lapho-ke futhi ubuyile wakhuluma khona njalo kuwukuthi lapho-ke lokhu akukho la ithimba labashushisi noma ithimba lozombuso-ke noma ihlangothi lozombuso la iqhamuke khona-ke nenkulumo kade khona-ke phakathi kwabantu labo-ke futhi abasolwa-ke lapho-ke noma inkulumo eqhamukile kusho ukuthi iyona-ke vele ebambekayo nesihlahla futhi nomsindo-ke lapho-ke abathi-ke la bathi khona-ke abasola bonkana futhi nokheli Khumalo kade bekhuluma khona-ke bonkana bephelele-ke futhi asho khona njathi umsola lapho-ke akangabekwa-ke amacala ngalokhu konke-ke akwenzile-ke noma lokhu bamthwesa ukuthi ukwenzile engakwenzanga futhi amacala wonkana womathathu futhi necala lesine futhi icala lesihlanu.
The legal position, I've referred to the provision of Section 174 of the Act. The corollary is that he ought to be acquitted. That is the accused, if it is reasonably possible true that he might be innocent. My own emphasis. The word no evidence in Section 174 of the Act means no evidence upon which a reasonable person might convict the accused, as stated by Ramsey J. Instead versus Kanyapa, 1979, Volume 1, SA 824, capital letter A in brackets, at page 834, paragraph F. It is well established that no evidence does not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully might convict. The question whether a court should grant the discharge at this stage is one which entails a discretion by the trial court. It is a discretion which must self-evidently be exercised judicially.
ngaphansi kwezomthetho-ke lapho-ke la ekhuluma phecelezi nodaba luka-section 174 lapho isicelo esithi aqhamuke ngaso-ke lapho-ke lathi khona ekugcineni kwecala lezombuso-ke lapho-ke kwamele ukuthi khona-ke njalo lapho-ke uma ngabe-ke abantu bebona ukuthi kanjalo abanalo icala phecelezi nabo kwamele balethe isicelo lesi-ke lapho-ke athi futhi kwamele ukuthi inkantolo uma ibabona bengenalo icala kwamele ukuthi badedele-ke ngoshweleke lapho noma ibadedele nje kuphela-ke lapho-ke wathi washo khona njalo lapho-ke nanoma kusho lokhu-ke athi ngaphansi kwezomthetho zika-section 174 lokhu akusho ukuthi ubufakazi lapho-ke abukho-ke lapho-ke ubufakazi obukhethekile ubufakazi obubambekayo lapho-ke obungaze buphoqelele thizeni-ke abasuke bagcine lapho-ke bethoswa-ke icala-ke lapho-ke futhi babeyaqhathanisa phakathi icala lapho lika-Ramf CJ futhi icala abhekene necala lozombuso-ke lapho-ke noma icala likaKhanyapa laka-1979 SACR SA 824 lapho-ke A futhi washo khona njalo lapho-ke kwamele lokhu kubhekwe futhi kubhekisiswe kahle-ke lapho-ke uma ngabe ufakazi lokhu kade ufakazi obukhethekile mhlawumbe ufakazi obubambekayo noma ufakazi obubambekayo obunesihlandla noma ufakazi obunomsindo lapho bungekho khona-ke kwamele ukuthi lapho inkosi yenkantolo mhlawumbe inkantolo lokhu isebenze ngendlela ekhethekile futhi ngendlela ejulile lapho thizeni-ke idedele-ke abantu-ke lapho-ke kumacala ade bathosa wona-ke.
The judicial pronouncement on the manner in which the trial court must exercise its discretion has been contentious. I do not intend to give a full historical overview. I will confine myself to a brief reference to those cases that help to define the scope of the court's discretion in terms of Section 174. In State versus Shopping and others, 1983, Volume 2, SA 119, capital letter B in bracket. The IMSTRA CJ reviewed the case law history of discharge application and formulated the test as follows at 120 to 121, capital letter A. And I quote, at the close of the state case when a discharge is considered, the first question is Roman figure 1. Is there evidence on which a reasonable person might convict? If not, Roman figure 2. Is there a reasonable possibility that the defense evidence might supplement the state case? If the answer to either question is yes, there should be no discharge and the accused should be placed on his defense. Close quotation. There is criticism in respect of the second test in the Shopping case. And the criticism labeled was referred to in State versus Lubaka 2001, Volume 2, SACR 702 SCA inter alia, as follows. At paragraph 14, the criticism of Shopping's case relates to the second leg of the inquiry, which permits an accused person to be placed on his defense, even when there is no case to answer, merely in the expectation that the defense evidence might supplement the prosecution's case. To place the accused on his defense in those circumstances has usually been said to be in conflict with the presumption of innocence. Close quotation.
phakathi kwelinye-ke icala selahlalela ngaphansi kwenkosi enkantolo-ke lapho-ke lecala kade akhuluma-ke ngalo-ke lapho-ke Shopping futhi nabanye-ke lapho-ke kadehle lapho-ke u-M3 uthi ijaji yakhona-ke lapho-ke nkuluma inkosi enkantolo-ke lapho-ke lathi khona-ke egcineni kwecala noma qhathanisa phakathi kwesicelo sakhe lesi futhi nesicelo secala leli eda-ke kukhuluma-ke ngalo-ke qala.
In State versus Lubata 2001, Volume 2, SACR 703 SCA, the following was said. The right to be discharged at that stage of the trial does not necessarily arise, in my view, from consideration relating to the burden of proof or its concomitant, the presumption of innocence, or the right to silence, or the right not to testify, but arguably from the consideration that more general application. Clearly, a person ought not to be prosecuted in the absence of a minimum of evidence upon which he might be convicted, merely in the expectation that at some stage he might incriminate himself. That is recognized by the common law principles that there should be a reasonable and probable cause to believe that the accused is guilty of an offense before a prosecution is initiated. See Beckenstrater versus Rota and Tiernesen, 1955, Volume 1, SA 129, capital letter A in bracket, at page 135, paragraph C to E. And the constitutional protection afforded to dignity and personal freedom in terms of Section 10 and 12 of the Constitution seems to reinforce it. It ought to follow that if the prosecution is not to be commenced without that minimum of evidence, so too should it is when the evidence finally falls below that threshold. That is preeminently to be so where the prosecution has exhausted the evidence and the conviction is no longer possible except by self-incrimination. A fair trial, in my view, will at that stage be stopped, for it threatens thereafter to infringe other constitutional rights protected by Section 10 and Section 12 of the Constitution, close quotation.
Nalapho phakathi kwicala lapho ke likambuso futhi icala likalubaxaka lapho iqala lango-2001 ngaphansi sokuthi volume 2 lapho ke CCR 703 lapho icala ka-inter ali lapho ke bayakhuluma phecelezi ngodaba lolu ke lesicelo sakhe sokuthi zena abasolo babadedeleke noma umsolo abadedeleke lapho ke bangamthwisa icala ngaphansi kuwonkana amacala ade bemthwesa wona ke lapho ke yilokhu nje kuphela kade kubalekile bekakhuluma ngakho ukuqhathanisa phakathi icala leliyana eselahlala ngaphambi kwenkosi enkantolo ngesikhathi nesindlule futhi icala lelakho lamanje.
It has been held that the credibility of state witnesses at this stage of the proceedings only play a very limited role. In State versus Mpeta and others, 1983, Volume 4, SA 262, capital letter C at 265 D to G, Williamson J. held that relevant evidence can only be ignored if it is of such poor quality that no reasonable person could possibly accept it. Close quotation. Therefore, to summarize the legal position regarding application in terms of Section 174 is as follows. An accused person is entitled to be discharged at the close of the case for the prosecution if there is no possibility of a conviction other than if he enters the witness box and incriminates himself. B. Credibility of witnesses' evidence is only an issue where it has been the effect that the evidence is so unreliable that it can be said that no evidence has been adduced. C. Where the evidence of the state witnesses indicating the accused is of such poor quality that it cannot be relied on, and there is accordingly no credible evidence on record upon which a court acting carefully may convict, an application for a discharge should be granted. D. An acquittal must be in the interest of justice. E. Circumstantial evidence in the state case may be relevant factor in deciding whether a case against the accused is so strong that it calls for a reply in the witness stand. It is against this legal background that I find it prudent to refer to the portions of the evidence of Zungu in the record of the proceedings and later proceed to analyze his evidence. Constable Sizwe Sikumbuzo Zungu testified that he was a constable employed by the South African Police Services with 12 years experience under the invisible policing station at Sebenza Police Station. He knows all the accused before court. He knew Mthokoziseni accused number 4. He remembers him from Phosphorus, but not back home. On the 26th of October 2014, he received a call from Gwabeni. Gwabeni wanted to know him, from him, that is Zungu, whether he was able to come to Phosphorus on that day. He responded that it was still early because it was around 7:15, and that on that day he was still going to work. Gwabeni called him again and informed him that there was another brother of ours, Makosonke from Rustenburg. He informed him that Makosonke was also going to be joining us. He knocked off and contacted Makosonke Zungu He informed him that he was at Johannesburg at Carlton Center. That is where he will find him. He went there and found him. They arrived at a hostel between 2 to 3. He will not be able to remember the exact time.
Lapho kade afunda phecelezi nodaba lolu-ke futhi washo khona njalo uma ibuka lapho icala lapho-ke lezombuso kade lapho lihlelwe inkosi yenkantolo lapho-ke uHomu-ke lapho-ke futhi icala lezombuso phakathi no-Aglito lango-2011 volume 2 lapho-ke CCR 437 lapho-ke beyakhuluma phecelezi nodaba lolu-ke lokuthi khona-ke lapho-ke uma ngabe icala seliphethe ifike emaphethelweni-ke lapho icala lezombuso-ke lapho-ke uma ngabe-ke umsolwa lapho-ke ngafisa ukwenza lokhu okulandelayo ngaphansi kwezomthetho-ke unakho ukuthi akwenzeke lo sicelo sesikhethekile lapho-ke lathi khona-ke umsolwa khona-ke njalo uvumelekile futhi unakho ukwenza lokhu-ke egcineni kwecala lezombuso lapho-ke ekuthizeni aqhamukise nesicelo sakhe lapho-ke noma mhlawumbe ayabiza abofakazi bakhe-ke lapho-ke noma ngene ngaphakathi kwebhokisi lapho-ke bese ayikhulumele noma mhlawumbe-ke lapho-ke azifake yena-ke kumathupha-ke ecaleni-ke lapho-ke athi lapho-ke uma ngabe sibuka futhi bofakazi ade bekhona-ke lapho-ke uma bengenaso isihlahla mhlawumbe isihlahla msindo lapho-ke kwamele ukuthi abasolwa lapho babadedele bababone futhi bengenacala lapho-ke wathi lokhu kukhona wathi lokhu kukhona uma buka phaka icala lapho-ke likambuso futhi noSwartz lapho-ke lango-1999 volume 1 lapho-ke CCR 319 lapho-ke open bracket besathi W lapho-ke noma usho ukuthi lapho ubufakazi bezombuso lapho-ke mhlawumbe noma abofakazi bezombuso lapho uma belethe ufakazi obungenasihlahla msindo noma ubufakazi lapho mhlawumbe-ke obungahambisani-ke lapho-ke noma ufakazi lapho mhlawumbe obuphuwa-ke lapho-ke obungenayo lapho-ke isihlahla msindo okubonayo-ke lapho ufakazi obomayelana nalolu daba lolu-ke athi kwamele inkosi yenkantolo lapho-ke ingagwebiki abasolwa noma ingabathuli-ke abasolwa benicala lapho-ke kwamele futhi ekuthizeni ibavumele uma ngabe sebeletha isicelo sabo sokuthi babadedele ngaphansi kwamacala wonke akade bebathusa wona-ke lapho-ke bathi ku-D lapho-ke usho ukuthi lapho lokhu kwamele ukuthi bakwenze ngaphansi kwezomthetho noma ngaphansi kwezamalungelo ezomthetho-ke lapho-ke futhi wabuya wathi washo khona njalo-ke lapho-ke wathi mayelana nofakazi bethimba lwezombuso loba abathi bona-ke banabo lapho-ke kwamele ukuthi inkosi yenkantolo futhi ibukisise futhi ibuke ngendlela ekhethekile futhi ngendlela-ke ejwayelekile engabuke ngendlela engajwayelekanga abofakazi lapho-ke kade bekhona-ke lapho-ke bese qhathanisa phakathi kwecala lezombuso-ke lapho-ke nocele lango-1986 volume 2 PHH 121 futhi washo khona njalo lapho-ke uma ngasisilapha ku-background-ke lapho-ke sithi abofakazi ade bekhona-ke lapho-ke bathi khona-ke ufakazi othizeni-ke lapho-ke okade bukhona ufakazi bakhe okade ekhona ngaphambi kwinkosi yenkantolo-ke lapho-ke bese washicelela ufakazi bakhe lapho-ke bathi uzungu bathi khona kwinto ekhuluma ngaphakathi kwenkosi yenkantolo-ke ngesikhathi bekalana-ke washo khona njalo yena-ke uconstable Sizwe Sikhumbuzo Zungu-ke lapho-ke ngesikhathi bekathula ufakazi bakhe-ke lapho-ke washo uconstable futhi usebenza ngaphansi kwezesiphoyisa-ke wathi uneminyaka eyi-12-ke isipiliyoni esebenza ngaphansi kwezesiphoyisa-ke futhi usebenza ngaphansi kwezesiphoyisa sasebenza police station-ke lapho-ke futhi washo yena ukuthi bonkana abasolwa uyabazi laba ade bekhona ngaphambi kwinkosi yenkantolo-ke futhi wathi yena umthokoziseni wamazi njengomsolwa wesine-ke lapho-ke ngesikhathi bekaqala kumbona lapho eFosforasi-ke kepha kanawo umkhumbulo wakhe wasemakhaya-ke athi ngelanga lenge-26 October nyaka 2014 yena kwathola ucingo kade liqhamuka kogwabeni bathi ugwabeni uyena-ke owazisa-ke uzungu noma watshala-ke uzungu okuwukuthi kwamele ukuthi afike eFosforasi ngalo-ke lela langa lelo-ke bese uzungu waphendula wathi yena-ke wabamshayela ngesikhathi sakusasa samahora kusasa-ke athi nge7:15 yakusasa-ke lapho-ke yena futhi bekazokuselela kuya emsebenzini ngesikhathi bekashayela lapho-ke bathi ugwabeni-ke nawe uyena-ke owamtshela khona njalo ukuthi khona-ke omunye umfowabo-ke lapho-ke noma umfowabo lapho-ke kade kwabathi uMakhosonke-ke baqhamuka ngaphansi noma kade aqhamuka-ke eRustenburg-ke uMakhosonke lapho-ke bathi wamtshela ukuthi uMakhosonke khona-ke naye futhi uzofika abajoyine-ke noma hlanganele nabo endaweni eyodwana-ke lapho-ke bathi yena-ke washayisa-ke emsebenzini ngesikhathi beshayisa emsebenzini-ke bese wathinta-ke uMakhosonke-ke lizungu-ke lapho-ke wamtshela ukuthi kumele bahlangane lapho eGoli eduze nase-Cartoon Center noma e-Cartoon Center-ke lapho-ke athi yona ndawo bekazomfica kuyo ngeleyo-ke uma ngabe sekashayisile emsebenzini-ke athi empeleni ngangiqiniso ogcina befika-ke lapho-ke hostele ngemuva kwehora lesibili noma ngehora lesithathu kade engasakhumbuli kahlehle ukuthi ngabe wafika ngasiphi-ke isikhathi lapho-ke.
It is against this background that I will proceed and analyze Zungu's evidence. According to the version of the state, the only witness who met and placed the accused at Phosphorus Hostel on the 26th of October 2014 was Constable Zungu, Constable Sizwe Skhumbuzo Zungu, who was a single witness. It is straight law that a court should approach the evidence of a single witness with caution. The following passage from the judgment of the Phyllis JP in R. vs. Mokoena, 1932 OPD 79 at page 80 is frequently cited. I quote, "The uncorroborated evidence of a single competent and credible witness is no doubt declared to be sufficient for a conviction. But Section 284 of Act 31 of 1917, that is the predecessor to Section to the Act 51 of 1977. But in my opinion, that section should only be relied on where the evidence of a single witness is clear and satisfactory in all material respects." Close quotation. Instead versus Weber, 1971, Volume 3, SA 754, capital letter A in bracket, the appellate division stressed that there was no magic formula which determines when the evidence of a single witness testimony may warrant a conviction in every case. What may be said, however, is that the evidence of a single witness has to be approached with caution. His or her merits as a witness must be weighed against factors which militate against his or her credibility. Thus, the mere fact that he or she has an interest or bias against the accused will not of itself obviate a conviction. It is necessary to assess the intensity of the bias in the light of the totality of the evidence. Close quotation.
mhlawumbe usuthi ithuma lezombuso esithi abahambisana nofakazi babo-ke ukuthi ibona-ke uyena ufakazi oyedwana kuphela lona-ke kade ubeka-ke abasolwa ngaphansi kwendawo sephosphorus lapho-ke wathi ufakazi lo-ke uconstable Sizwe Skhumbuzo Zungu-ke owasokwazi ukuthi mina-ke kade likhona-ke lapho-ke lokuzana lapho-ke ethuba-ke futhi obuye wasokhona ngathi ethimba lezombuso futhi nenkantolo-ke lapho-ke akumele ukuthi lapho-ke uma sebuka kufakazi babuke bufakazi oyedwa-ke osuthi ufakazi oyedwa-ke loyo-ke osuke esikhathini esiningi-ke ebeka-ke labantu abasolwa-ke ngaphansi kwendawo yesigameko-ke noma ngaphansi kwendawo ekhethekile noma ngaphansi kwendawo ethizeni-ke lapho-ke ngoba bathi lokho esikhathini esiningi usuke akwenza ngokuthi na-ke mhlawumbe unento-ke mhlawumbe sushuthi mhlawumbe angayithandile kubona mhlawumbe engahambisani-ke nabo-ke noma mhlawumbe eyenza lokhu kwenza lokhu-ke ngokuthi ufuna ukuthi abantu abasuthi mhlawumbe abacekela phansi-ke lapho-ke noma futhi bababone-ke benecala-ke abantu labo-ke bathi inkosi enkantolo kwamele ukuthi lokhu kubuke futhi ngendlela-ke ekhethekile futhi nangendlela-ke ejulile.
Corroboration. In State vs. Gently 2005, Volume 1, in bracket SACR 420 at 430, Clute JA in dealing with the approach to be followed by a court when it is faced with a situation where a court should caution itself in analyzing the evidence, said the following, I quote, "It must be emphasized immediately that by corroboration is meant other evidence which support the evidence of the complainant and which renders the evidence of the accused less probable on the issue in dispute," close quotation. It is clear from the authorities that if corroboration was required, if it had, for purposes of the so-called cautionary rule, to be corroboration implicating the accused, and not merely corroboration in the material respect or respects. The evidence of Zungu was not corroborated in all material respects. Skhumbuzo Zungu was not called by the state to corroborate the version of Zungu, insofar as traveling with Zungu to the hostel after he had received a call from Gwabeni to pick up Skhumbuzo Zungu at Carton Center in Johannesburg. Zungu is the only witness who met the accused at Phosphorus Hostel. He was introduced to the accused by Gwabeni. It is surprising that this introduction was done to this witness when Zungu and the accused knew each other. Zungu testified that he was requested by a certain gentleman, that is accused number 5, was requesting him to remove his vehicle because he had parked behind the vehicle that accused number 5 was traveling. Zungu and others he was seated with went to buy liquor and they drove using an Uno motor vehicle. He was traveling with accused 2, accused 3, and the driver. There were 5 in total. From the body of Zungu's evidence, this is the only time that he had traveled with accused 2 and accused number 3.
Lapho futhi bekade afunda khona ke phansi but ufakazi lokuba kade buhambisana ke lapho ke athi lokho sibuka ngaphansi uma eqhathanisa kumacala ke lapho ke icala lapho ke lozombuso ke libhekene icala lapho lika Gentile 2005 ke lapho ke volume 1 ACCR 420 ke lapho ke futhi ngaphansi ku 430 ke lapho ke futhi inkosi enkantolo lapho kade ku-include JA lapho ke athi ngesikhathi kade kusenzeka lokhu ke ushuthi noma eqhathanisa ke lapho ke athi inkosi enkantolo kwamele lokho ikubukisise ngendlela eqondile futhi ngendlela ekhethekile ke lobu lofakazi obulandelayo ke noma mhlawumbe ebufakazi obulandelayo lapho ke lapho khona ke kwamele ukuthi lokho bakwenze benze iqinisekiso ubufakazi labo buyahambisana bonkana futhi bonkana nofakazi babantu ade bevule icala lapho ke buyahambisana ufakazi bonkana babufakazi esube bezolothwa ngaphambi kwenkosi enkantolo lapho ke besathi ummeli lapho ke uma eseyafuka lapho ku 14.2 lapho ke athi cace bha ukuthi lapho ke lokho akaze kwenziwe ke lapho ke noma kade akwenziwe ngendlela ekhethekile lapho ke ngoma uma sekhona lapho ngeconstitutional rule ke lapho ke somthetho okhethekile lapho ke ubufakazi ushuthi lapho obuquka khona ke abasola bonkana noma ufaka ngaphathi abasola bonkana ke lapho ke bathi lapho ke ufakazi oyedwa lapho uZungu ke wena ufakazi bakhe futhi nabo ke akade bungahambisani ngaso sonke ke isikhathi lapho ke ngoba kumayelana nenkulumo yakhe ke uZungu yena ke into ayikhuluma ukuthi yena ke kade ehamba ke lapho ke noZungu ngaphakathi kwemoto ngesikhathi besiya lapho ke elokozana kulenda kade beyakuyona ngemuva ukuthi athole ucingo eqhanga uqhamuke kugwabeni emcela ukuthi akahambe ayodobha ulokozana omunye kuZungu lapho ke Carton Center yakhe eceliwe lapho kusikhumbuzo uZungu ke nake egoli ke athi uZungu ngesikhathi ade kusenzeka lokhu ke futhi wafika ke ehostel sohlangana nabo ke abasolwa ke lapho ke athi ngesikhathi bahlangana nabasolwa ke hostel ke lapho ke athi uyena ke ugwabeni owamazisa ke kubona ke abasolwa ke lapho ke noma lo hlelo uthile bona ke bazane ke lapho ke bathi lo hlelo lwenziwa ke lapho ugwabeni ke ngemuva ukuthi kwenziwa lokho ke bathi uZungu obuye futhi wakhuluma khona njalo ke lapho ke athi khona ke lapho ke umuntu wakhuluma naye lapho ke umsola wesihlanu ke lapho ke ngesikhathi edemcitha akasuse ke imoto yakhe ngemuva kwemoto yakhe ke la kade imise khona ke ngoba uZungu imoto kade ehamba ngayo kade ime ngemuva kwalapho ke noma umsola wesihlanu umuntu kade ehamba ngayo kade ime lapho ke nayo ke futhi bathi uZungu futhi nabanye ke lapho kade behlezi lapho ke phansi besijabulela ke lapho ke bese bahamba bothenga ke lapho ke iphuzo ke zokudakwa ke lapho ke bahamba basebenzisa ke imoto yakhe kuyiuno lapho iuno imoto yakhe besebenzisa lapho kade behamba lapho ke futhi bathi ngesikhathi kade behamba kade khona kumsolo wesibili umsolo wesithathu nomshayeli futhi ngesikhathi behamba bonke kade kade bebahlanu ngaphakathi kwaleya moto ngesikhathi lesigibeshala behamba ngayo ke lapho ke bathi uZungu yena ke lapho ke yena ke wakhuluma njalo ukuthi yena ke umuntu ahamba naye kumsolo wesibili futhi nomsolo wesithathu.
In his affidavit dated the 23rd of May 2023, which was obtained some 4 years later after Brigadier had taken over this investigation, page 2, paragraph 4, line 10 to 11, Zungu states the following, and I quote, I must also at some point went out to the shops to buy some alcohol and drinks with a certain lady and came back to Gwabeni's house. Close quotation. It is clear that Zungu does not place the accused, that is accused number 4, traveling together using the VW Polo hatchback grey in color that he alleged accused number 5 was using, leaving the hostel, and part of his evidence is that he saw accused 1, 2, and 3 coming in, following each other, going towards Gwabeni's room, and he followed them. Inside the room, accused 1 was in possession of a .38 special revolver, and accused number 3 was in possession of a 9mm pistol. Accused 5 came inside the room. He was followed by accused number 4. Zungu states the following at page 2, paragraph 5, line 1 to 3 of his affidavit, and I quote, "Around 9 p.m. on the very same day, I noticed Moses Spear Maphisa, open bracket, Sunday Sontanzi, close bracket, and Kani, open brackets, Fisokuhle Zungu Ntuli, close bracket, walking after each other to Kwabeni's bedroom from outside. It does not mention accused number 4, following accused number 5 to Kwabeni's room. At page 2 of his affidavit, paragraph 5, line 6 to 9, he states the following, and I quote, "I saw Moses giving Kwabeni a .88 special firearm and Kani giving Kwabeni a 9mm firearm," close quotation. At page 2 of his affidavit, paragraph 5, line 20 to 21, he states the following, and I quote, "Mthokoziseni Maphisa and Carlos Ncube walked into the bedroom and sat on the bed," close quotation. There are material contradictions between Zungu's evidence in chief and his written statement. The correct approach to any contradiction between the prior statement and the witness's testimony was, in respect, most useful, summarized by Olifield J.A. Instead versus Mafada Diso in another, 2003, volume 1, SACR 583 SCA. The head notes in that case is submitted accurately, reflected, was said and was cited by Nechben J. Instead versus Governor and another, 2006, volume 1, SACR 322, capital letter E in bracket. In respect of the factual evidence of Zungu's evidence, the contradictions are material and affect his credibility. During cross-examination by Mr. Ramsepel in respect of Zungu knowing accused 2, this is how Zungu responded, and I quote, Mr. Ramsepel, "Now, accused number 2, because I will chop and change with respect to accused 1 and 2, but accused 2 himself says he does not know you in total. He just see you here yesterday in court, Mr. Zungu. If that was said or was coming from accused 3, 4, and 5, I would have agreed with you. Okay, where I was born or back home, where I was born, or he is Ndanzi. It is clear from Mr. Zungu's evidence, when question is posed to him by Mr. Ramsepele in respect of him knowing accused number 2, his response was that if that was said by accused 3, 4, and 5, that they did not know him in total, he was going to agree. The response by Zungu is a clear indication that he did not know accused 4, in the light of the fact that he says he was going to admit that he did not know accused 4 if such assertion was put to him by accused number 4. During cross-examination, Zungu testified that a typed version of his statement was made out of notes that he had written himself. And where there are contradictions in paragraph 5, he actually meant accused 4 and 5 entered Gwabeni's room and not accused 3. During cross-examination by Mr. Ramsepele about Zungu mentioning in his written statement that he went to Top Spa to buy liquor in the company of a lady, this is how Zungu responded. Mr. Zungu, I think maybe it is a manner in which it is put here, but I did go to Tops with the gentleman. We came back and then there is a lady that just want to go nearby, who had requested me to buy her a drink, and I did go out with that lady. In his evidence in chief, Zungu testified that the person wearing a cap was accused number 2 when he was confronted that in fact the person wearing a cap was accused number 4. He could not proffer any explanation. Zungu testified that at some point he met Brigadier Lishabane, who informed him that he was going to conduct his own investigations, and thereafter he would come back and inform him, but did not tell General Lishabane that he was at the hostel. The reason was that he did not want to give General Leshabane this information, that it was coming from him, and that he did not have certainty with regard to that. Clearly, Zungu had an axe to grind for the accused when one considers the compactness of his evidence. Zungu testified further that on the 13th of November 2013, he had a meeting with Brigadier Gininda. Brigadier Gininda asked him what he knew about the killing of Senzo Meyiwa. He told Brigadier that he knew nothing and there was nothing that he can talk about. Brigadier Gininda told him that he was going to do his own investigations. At that meeting, Brigadier Gininda was with Brigadier Tony. Zungu testified that the relatives of accused number 1 wanted to shoot him. He spoke to accused number 1 over the phone and asked accused number 1 why his relative wanted to shoot him, because he, Zungu, also did not know anything about this matter and did not know anything. It is clear, my lord, that from the responses or the evidence of Zungu, he mentions that not even on one occasion that he did not know anything about this case. He said this in the presence of General Leshabane. And on the 13th of November, when he had a meeting with Brigadier Gininda, he repeated the very same assertions that he did not know anything or knew nothing about the killing of the deceased. Thirdly, he mentioned this when he spoke, as he said, to accused number 1, when he was making inquiries about why his relative wanted to kill him, because he did not know anything about this case. Further, to proceed, Zungu could not explain what was the occasion on page, I'll come back to that, of Exhibit C, despite claiming that he was with accused 3 and 4 on the day of that occasion, the date of the 26th of October, 2014.
But you're saying Zungu's evidence is not corroborated in any of the evidence led in this court?
Yes,
Never.
never.
Remember, what's the time they say?
It's 11:30, my lord.
Yeah, well, you remember there was evidence by Buthelezi, a gentleman called Buthelezi, who went to see accused number 1 to give him some washing items. Sorry, number 2, yeah, you're right. In Rustenburg, next to some supermarket there.
Yes, I remember that evidence, my lord, very well.
Yeah. And then there's another piece of evidence. I don't know if it's accused number 1, who was drinking Irish whiskey and exclaimed that Senzo is no more. Senzo is no more. You don't remember that?
I remember that.
Okay, on that note, let's go and have a drink.